Good evening, colleagues. Welcome to this session tonight, which is about the agency workers regulations. Hopefully going to help assist you in any potential for a claim in respect of the regulations, particularly those regarding the right to equal pay. I noticed there are a number of you already in the webinar, apologies. But we'll give it a few more minutes, see how many more people come before we get into the meat of the issues for tonight. Just to introduce myself, my name is Paul Watkins, and I'm National Negotiating Official for the union. And one of the areas I have the responsibility for is issues relating to supply teachers. And I'm joined tonight by Colin Adkins. Would you like to introduce yourself, Colin?
Good evening, everyone. My name's Colin Adkins. I'm a caseworker in Wales, the nation of Wales, not the region of Wales. And I've picked up a number of cases where we're pursuing claims under the agency worker regulations. I've currently got 6 claims lodged and 2 more being lodged this week as well. So that would make 8 in total.
Yeah, so Colin's here tonight because Colin and I have worked together quite a number of times on a range of issues relating to the regulations. Colin has the more practical side of it because he deals with the cases and the specifics of the cases and what tribunals are looking for or not looking for. So we've worked together to produce some more information, which is available on the website. But obviously one of the things we wanted to do tonight was talk to colleagues about this and members about it. And Colin gives you the insight from the perspective of dealing with a case and going through a case and the logistics of taking it through. So that's going to be really helpful. In terms of logistics for this evening, if there's anybody out there who does want to make a comment, then obviously use the comment box, the chat box, but we will only take questions that are put in the Q&A box, because obviously in the chat box, people like to talk, say, hi, I'm Laura from Wales, or I'm Laura from Birmingham, whatever. Whereas it tends to mean it's difficult to filter out the questions. So if you have questions, do use the Q&A box and the functionality of that, and we'll try and answer all the questions. It is being recorded this evening, so if there are questions Colin and I don't get to or pick up, then we make a commitment to come back on those accordingly and address them as best we can. If there's a question that's specific to you, then obviously if you do put it in the Q&A box, it might be beneficial for you to put your email address so that we can then make sure we correspond with you in terms of going forwards if we don't address your question or query this evening. So give it just a couple of more minutes till 5 past, I think. I'll make it 3 minutes past 6. We've got a number of participants is steadily increasing. Okay, Shirley, I don't know. I'm assuming you have no sound your end, or are you saying you can't hear us? I'm hoping, Colin, you can hear me. I hope.
I can, yes.
Good. I have had many technical glitches with the joys of Zoom in my time. So what do you think, Colin? Do you think we should start?
Yes, I think so, yes.
Okay, right, brilliant. Okay, colleagues, we'll get underway. And as I said, if you've got any questions as we go through the presentations, then do put it in the Q&A box. I will be sharing my screen now because we've got a presentation and we'll be taking you through the presentation. And at some point during that presentation, I'll hand over to Colin, and Colin will take you through aspects of his area of expertise in terms of dealing with cases as a caseworker for the union. Right. Okay, hopefully this all works. I'm assuming people can see that. Colin, is that okay? Can you see?
Sorry.
Can you see
yes,
that?
I can. That's my slide. So that's at the end, isn't it? So.
Yeah. Okay. Brilliant. Brilliant. Okay. Right. So, purpose of this evening is to basically give advice and guidance to you as our supply teacher members who may be thinking about making a claim because you think you're entitled to make a claim, particularly and specifically around the issue of equal pay under the agency workers regulations. So hopefully we'll assist you in that in terms of providing you with some advice and guidance about how to do that going forwards. And it's important to see and understand that the there is a journey that supply teachers go on when they start undertaking assignments working through an agency and or umbrella company. So obviously there are sort of rights that you're ascribed and given on day one. Those rights are both under the agency workers regulations, or the AWR, and also under the conduct regs. So under the AWR, you have the day one right to access collective facilities and amenities such as a staff room, staff toilets, etc., canteens, etc. And they are supposed to provide you with information on vacancies. And under the conduct regs, you are entitled to, when you sign up to an agency, a key information document or KID, which will include a written statement of particulars. Now, obviously, the conduct regs are different to the agency workers regulations, and we are specifically tonight going to focus more on the agency workers regulations, and particularly those that come to an agency worker in terms of their rights after 12 weeks and the rights around the basic conditions of pay. If any of you are familiar with the seminars we offer twice a year, you will know that we have done stuff around the conduct regs, and we have done that a number of times now at different events. But I'm happy to, if colleagues consider it appropriate, take that away and consider doing something like this, a webinar around the conduct regs in the new year. Okay, so when you look at agency workers in terms of the definition of an agency worker under the agency workers regulations, agency workers are considered to be workers, not employees. So in very simplistic terms, you do have sort of three categories of worker within the United Kingdom. You've got somebody who's an employee who's on a permanent contract, say in a school or college. You've got workers, which would categorize supply teachers, and then you've got those that are classified as self-employed. And there are different tests that employment tribunals use to make an assessment of whether or not you're one of those or fall into those different categories. So under the agency workers regulations, under Regulation 3, it defines an agency worker specifically as somebody who is supplied by a temporary work agency, so your supply agency, that provides you to a school, and when you go to that school or the hirer, we'll talk about that in a minute, then you're working under the supervision, direction and control of that hirer or that school. And you have a contract with the temporary work agency, which is either a contract of employment with the agency or any other contract with the agency to perform work or services personally for them. So the term is quite, in terms of workers and the way in which the agency workers regulations defines an agency worker, there's quite a specific definition, and the category is that you are under supervision, direction and control, but you're on a contract that's different to a permanent employee. And it's important to understand when you look at this, the hirer, and this is language that's often used, and I'm sure Colin will attest this later on, this is the sort of language you may see bandied around in the tribunal in terms of who is seen as being the hirer. And in essence, when we talk about the hirer is, put quite simply, the client is the end user. So in most cases, for you as a supply teacher working through an agency and or umbrella company, the hirer is the school. Okay, so they are the organization, the employer that rings up and says to the agency, I need a supply teacher, I need them tomorrow until the end of the week, and they are the hirer. Okay, so they are the person or entity through whom the agency worker is supplied, and the person who's responsible for supervising and directing you. So clearly, when you go to school, the school and the management of the school are going to supervise, direct and control the work you do. So it's a key distinction between you being self-employed, isn't it? Because self-employment, you could have the right of substitution, and clearly in a school setting, you're not going to be able to substitute yourself and say somebody else is going to do my work today, because that would set all alarm bells off in terms of safety and issues around keeping children safe. So the hirer is something that needs to be considered in each of the cases, but often it will be the school, but sometimes it may, you could have a situation where the same hirer. So if you were to move between schools, okay, then the same hirer, it could be a local authority. So if you move between different schools and they're all local authority schools, then that could be seen as the same hirer, because in essence, the local authority is issuing the contract in terms of paying you, etc. Or you may have connected hirers. Okay, so it's important just to understand, and this will be helpful later on when we talk about the sort of information you need to gather in terms of who is employing you, and whether they're the same hirer or connected hirers. Okay, so obviously a multi-academy trust and maintain schools, is the employer the multi-academy trust? Are they the ones that are paying you? And are you going between different multi-academy schools? Okay. So as we said at the beginning of this webinar, we did talk about this in terms of specifically focusing on the rights after 12 weeks, because we know that is an issue, and a lot of supply teachers that come to our events do raise the issue of the rights after 12 weeks. So Regulation 5 of the Agency Workers Regulations is very clear that following 12 continuous weeks in the same role, and we'll be talking about that in a minute, with the same hirer. So hopefully we've cleared that up. Supply teachers employed by an agency have the right to the same basic conditions of pay. And I think it's important to understand it is quite clearly defined in the legislation as basic. So it doesn't extend to some things like, for example, the teachers' pension schemes, because that is an occupational pension scheme, or the occupational sick pay scheme, which for teachers in England and Wales is often described in terms of the Burgundy Book. Okay, so it wouldn't extend beyond that to those things because they are occupational things, they're not basic. So basic conditions of pay are things like the rate of pay, the hours of work, rest breaks, duration of working time, and annual leave. And it's important to notice that obviously an element of annual leave is included in the daily rates that schools pay if you're covered by the School Teachers Pay and Conditions document, or the STPC-WD for Wales, because obviously Wales has devolved powers for teachers in terms of their contractual terms and conditions. So I do think it's important to understand that there is the basic conditions that you would be entitled to make a claim for in terms of after 12 weeks. Okay, so the same role. I think this is where, in many respects, and Colin, you may want to chip in here, but in many respects, teaching is quite unique because we don't necessarily split issues around what subject you teach, but that's a different subject. We tend to say a teacher is a teacher, and as such, the same role is quite difficult to in our view, and Colin will attest to this in terms of cases he argues, it's very difficult for the employer or the agency to say, well, they're really different roles, because we'd be saying, well, what about it that's doesn't use the skills, professional expertise and experience of a teacher. Okay, so teachers can teach different key stages. Teachers can teach different year groups. Teachers can teach different subjects. That doesn't mean the role is substantially different. And I think that's an argument that we have always made, and we robustly make. And I know Colin, in his experience of cases, continues to make on behalf of members. The roles aren't drastically different. But I think, again, we'll go back to that in a minute in terms of the information. It'd be really helpful for you to gather in order to help us practically look at a claim and assess a claim in terms of whether it's a valid claim and we can take it forward. So in terms of guidance, a role is considered the same role unless it involves a substantially different type of work. So in bold there are quite important words, substantially different. So is it substantially different to teach a different key stage? I wouldn't necessarily argue it is. Is it substantially different to teach a different subject? I don't necessarily think it is. And advice and guidance, which was published a couple of years ago now from the Department for Business, Energy and Industrial Strategy, or BEIS, does make it really clear that the work or duties which make up the whole or main part of the job must be substantially different. In essence, what we're saying is there has to be a genuine and real difference to the role. So if you're a teacher in a school, yes, you might need some additional training, but is the job distinctly different? Is it really, are the duties very, very drastically different? And Colin and I, in Colin dealing with casework, we would argue that it's very difficult for an employer to assert that they are substantially different. And we make that argument when we can all the time. Okay, so and it's important to understand this, because if an employer wants to reset the clock and say, well, we want to start reset back at 0 again in terms of you acquiring your rights after 12 weeks, then in order to do that, the hirer has to notify your agency and or umbrella company that the work or duties have changed. So a question that might want to be raised coming out of this tonight is, do you know if the hirer notified your agency, if you're thinking of making a claim, that the work or duties had changed? And it must be confirmed in writing to you. So you must, in essence, get a copy of that, and it must say well, the roles are substantially different. Even if the employer does that, though, there is still an argument we would make and take forward, which is, well, what is different about being a teacher in one key stage to another, etc., or across a different range of subjects? Okay, we, as a union, as an organisation, consider all classroom teaching conducted by a supply teacher would be the same role, irrespective of a change in subject, age range of the pupils that are taught in the school. Okay, it would not be enough, in our view, and Colin again will attest to this in his experience in casework. It's not simply enough for you to be asked to teach a different subject or a different age range of students, as all teaching, if you think about it, requires the professional skills and expertise when undertaking specified work, such as planning, preparing, delivering lessons and courses to students, and assessing and reporting on the development, progress, and attainment. So these are key things. So all teachers do those things. All teachers use their skills for specified work, and that specified work is the same irrespective of the subject taught, the key stage taught, and the pupils that you teach. You're still going to be planning, preparing, and delivering lessons and courses. You're going to assess those students, report on their development and their progress and attainment. So it's very different. It's very, difficult for somebody to make an argument that somebody teaching different key stages, that makes the job substantially different. And we would certainly look at that and the merits of the case in terms of taking it forwards. So when looking at equal treatment in terms of equal pay under the regulations contained in the agency workers regulations, we need a comparator. And it's really important to understand what the comparator looks like and how to assess the appropriate comparator. And Colin has dealt with this lots in the cases he deals with in terms of the comparators. And there are some simple rules of thumb you can use. So and again, BAYS and their advice and guidance, which can be used in an employment tribunal in terms of how the agency workers regulations are interpreted and applied. They talk about this idea of as if. And when we look at that, basically what it means is you should be treated equally as if you've been employed directly to undertake the same job. Okay, so the as if principle is really essential in terms of comparator. Okay, so it should be somebody who is engaged in broadly similar work to you. Okay, now it should be the comparator is important in terms of the skills and qualifications they've got. Okay, and account should be taken potentially of your skills and qualifications. Now, I believe, and would make an argument, I'm sure Colin would, that the skills and qualifications also include the length of years you've taught, because over time you will become more skilled and experienced in terms of your teaching. So that may again justify using a comparator that's not, say, the bottom, e.g. an M1 teacher in school, but saying, if I'd have employed you, so as if I'd have employed you directly, clearly I wouldn't have employed you on M1 because of your skills and experience, and because basically we just wouldn't, because we would look at it and say, well, we're going to employ you as an M2 teacher, because that's what you were doing substantive. Yeah, that's the qualifications and the pay you are getting and receiving in your previous job. Okay, now BAYS is quite helpful, and the advice and guidance it's issued, because it actually does clearly say if you work in an environment where there are pay scales, then you need to also consider at what point on those pay scales the employer, as if, using the as if principle, would have employed you if they'd have gone to employ you directly. So if you were in an interview for a permanent role in that school, what would they have employed you on? The as if principle. Now, if there are pay scales and you were an M4 teacher in your previous school and your skills and qualifications demonstrate that you'd had years of experience which took you to M4, then it would seem highly unlikely that that school would have employed you on M1. And that's an argument we would have to make. And I know Colin's made those arguments very successfully in the past, okay? So if it's highly likely that you would have been employed on a higher point if they'd employed you directly, it would, in the BAYS guidances referencing this, it would be quite inappropriate if you're paid at the bottom of the scale that's used in your school or college. Now, there are a couple of points for colleagues on the webinar tonight to understand as well. Now, it's important to understand the School Teachers Pay and Conditions document in England, as of 2030, removed pay portability. Okay, so a new employer is not necessarily required to match your previous pay when you go to a new post in a new school. However, now it's important to pay portability, and I don't want to deny the significance of it, but you still can then fall back on the as if principle, because it still would be argued that the person would have not, the school would not necessarily employ you directly on the lowest rung of the ladder, because obviously, yeah, you've got skills and expertise. They advertise the job at the bottom to the top of the pay range. So therefore, where were you slotted in on that school's salary based on your skills and expertise? So even though pay portability isn't something that's mandatory anymore, there is still an argument about the as if principle. And I think, you know, we can get hung up on pay portability. It's important and it is significant. However, doesn't mean it's game over, because we then need to consider the as if principle. Okay, so it's important when we talk in a minute about the sort of information and digging around we think you as supply teachers should do to come armed and prepared with a claim. You know, look at things like the pay policy. Pay policies, in my experience, often will say that they will honour pay portability. Often it says things like in principle. So there's an argument that they would have honoured pay portability, but they're not bound by it. But it still means, yeah, how many other people that they employed directly did they, for the purposes of your claim, did they honour pay portability for? Because then that adds to the weight of your claim, because they've done it with other people on a permanent basis. What would they have done with you if they'd have employed you directly? Okay, so you need to check pay policies carefully. The STPCD in England does, for this year now, contain reference to advisory pay scales. So again, this idea of pay scales, where would you have sat on the pay scales? Really important. So is your school, or is the trust, or is the local authority adopting the advisory pay scales in the STPCD? And from Colin's information working in Wales, they are mandatory in Wales. So there's a much stronger argument in Wales. Well, what would they have employed you on? These are mandatory pay scales. This is where you'd have fallen on the as if principle. Okay, but it is important to bear in mind academies and free schools can set their own pay scales in terms of employment. So you'd need to carefully look. It may not be that they're adopting or following the advisory points in the STPCD. My experience, again, dealing with 30 plus employers in England, is the vast majority do still stick with the STPCD and the advisory scales. So again, that works to our advantage when we're looking at the situation for you as a supply teacher and potentially making a claim or taking a claim forwards. So the key issue is the comparator, okay? And looking at what you're doing. Okay, so it is important, and it is important, we'll talk about this in a minute, in terms of collecting the information and gathering the information of what you as a supply teacher consider you've been doing, because obviously that can add to the weight and the evidence to say the comparator is higher up the pay scale than maybe lower down. Okay, so when we're looking at a 12-week qualifying period, the assignment must be continuous, although it's important to bear in mind not all breaks interrupt continuity. So we'll talk about this in a minute. There are some breaks in terms of break in the service that you've done that would pause the clock, and others that stop it, and others where the clock continues. So it's important to understand that, and we'll look at that in a minute. There are no minimum hours that you should work in a week. A lot of people suddenly think, well, they won't be eligible because they're only doing a couple of hours here and there in that academy or that school. But there is no minimum, minimum or set level of hours that you've got to work in any week. Any time you spend working in any week is calculated for the purposes of you hitting the 12-week period. Okay, and obviously just a housekeeping issue, a week for the regulations is defined as a calendar week starting on a day or on the day the worker starts with the hirer. So we're talking about different breaks. So some breaks pause the period, some breaks set the clock to 0, and some breaks the clock continues. So if you look at an agency worker who is on maternity leave or paternity or adoption leave, these weeks all count. So if you're on leave for those periods of time, it would still count towards your qualifying period for the agency workers regulations. Any breaks that are less than 6 weeks, they simply pause the period. So if you're a supply teacher working in a school and there's the summer break and then you come back to work in the same school again, that would just pause the period and you'd start to acquire the qualifying period for the agency workers regulations. If you're on jury service or you have up to 28 weeks sickness absence, that will pause the period. Annual leave, or I think they use in the Bayes guidance, Colin might correct me, I think they use factory shutdowns, but I think we would use sort of school holidays as being equivalent for like a factory shutdown. So again, it just pauses the period. Okay, if you begin a new assignment with a new hirer, quite clearly that sets the clock to 0. And if you remain with the same hirer but no longer in the same role, so again, if there's a valid argument you're doing a substantially different role, then that would set the clock back to 0. And interesting to note, given that we are now balloting members over industrial action, any industrial action taken does just pause the period. Okay, so you could, as an agency worker, move between schools as long as the employer does not change and the role is substantially the same without stopping the clock for the purposes of qualifying. Okay. So in terms, again, of you as an agency worker gathering information and being able to come to us and saying, I think I've got a claim, because we all know when we deal with claims, the first thing is we start looking at the information that is available, what you've got, what you've gathered, and we can then make an assessment of the merits of the case and whether we can take it forwards. So Regulation 16 is about this, because if you suspect there is a breach of your right to equal pay, you should write to the agency in the first instance, and you should write saying you want to assert your rights. The agency is supposed to reply within 28 days, providing the reasons for its actions. If the agency doesn't reply, you can then make the same request direct to the employer. There is no specific remedy in terms of if somebody doesn't do this, there's no specific remedy for their failure to reply, either the school or the agency. However, it's referenced quite a lot this, an employment tribunal could draw an adverse inference from any failure in terms of believing that's evasive in terms of its tactics. So again, if you've, we expect you to do some digging around, we expect you to assert your rights and to assist you on the website. If you go in and you type agency workers regulations, we have got some template letters that you can use. So we've got template letters that account for whether you're in Wales and it's the STPC WD, or in England it's the STPCD, or in England, you've got a trust that doesn't adopt the STPCD. We've concocted letters and drafted template letters that you can use when you think you want the right to receive the information about your right to equal payment and equal treatment under the relevant regulations for AWR. So we have assisted you there and provided some template letters which you can find on the website. Just go in when you get the search functionality on the website, just type in agency workers regulations and it will come up, and just click onto that, and there's some resources, further resources I think they are. Click on the right hand side and there'll be template letters for you to use. So how can you, and I think this is important, we have to see it as a bit of teamwork, because we will represent you, but we will often set you the task of, have you got this to hand? Have you investigated this? So if you think you're in a situation where you are going to be able to assert your right to a claim, how can you assist us in preparing that case? So there are a range of things for you to consider in terms of taking a case forward. So for example, when you go into an agency, make sure you inform them of your work history. So including if you've worked for the same employer before, okay? So make sure you're up front. What's your work history like? What was the level of pay you were last working at in terms of a daily rate, or if you've come into supply for a permanent job, what were you doing? Were you on the upper pay range, for example, or the upper pay spine? So make sure they're aware of that, because that helps us in terms of helping you, okay? Ensure that you fully disclose the level of pay and point of pay scale you were on in your most recent school or permanent employment. So I've answered my own question there, or I've gone through a point I was going to make next before. So yeah, so do check, do make sure you've got details. If you're paid on the upper pay range, what you were paid on the last time, the pay scale, the annual salary, any evidence you may have retained in terms of your threshold application. So these things are really helpful, because if you're telling the agency about this, then it does make it harder or make it more tricky for an argument to be made you should be paid at M1, for example, and not at a rate that's higher. Okay, ensure the information is communicated to the agency at or approaching 12 weeks. So, make sure you've communicated this information, and it's not something that lands after. It lands, basically, really, as soon as possible, I would make an argument. Make sure you document the teaching roles or teaching roles that you've undertaken, the subjects being taught, the age ranges being covered. Is it GCSE A level, Key Stage 2, Key Stage 3, Key Stage 4, Key Stage 5? Any information you can gather on the job descriptions. What are you being expected to do? So make it clear that you've asked what are the expectations of you as a supply teacher. Maybe look at the expectations of a job description for that particular employer and sort of tick off what you think you are doing. Okay, so what are the expectations you're doing? Are there differences or distinctions in the expectations that are placed upon you by the employer? The rate at which you're paid, has this varied between the different teaching roles that you may have been asked to undertake when working in a school or on an assignment? So if it's not varied, but you've been asked to do different things, different subjects, etc., then it does make it harder for the employer or the agency to argue that the role is substantially different, because you're still attracting the same rate of pay. Okay, so this is all the sort of stuff that is helpful and how you can assist us in preparing a case. If you'd worked under different line managers, different departments, that information is quite helpful and useful to have as well to hand. It doesn't necessarily make the argument for you getting your pay any weaker. It's just basically making sure you've got this information so we can make a better assessment of any potential claim. Okay. Have you worked across different schools or colleges, but they are within the same HIRA? So the same multi-academy trust, the same local authority. Okay. So again, information we would need to know. If you're asked to work different hours, again, it doesn't necessarily detract from the case, but it's just helpful to know. And obviously, if there are changes to any teaching roles, does it require any additional training or specific qualification? Yeah. So again, if you have worked at the same school or college and you're approaching 12 weeks, or it's 12 weeks or in excess of 12 weeks, you know, have you got evidence of all the dates worked, any reasons for any gaps? If you work with the same hirer through more than one agency over the course of the 12-week period. So again, have you retained that? Have you been able to access the school's pay policy? Does it provide for pay portability? Does the pay policy distinguish, as most do, between the upper pay range and the made pay range? Is there a qualification process to access the upper pay range? Because again, that's important in terms of you were on that before in a previous role. Okay, does it make reference to the STPCD in England or the STPCWD for Wales? Okay, and have you been able to source any information about job adverts? Are job adverts showing that they basically are quite open about the pay scales, e.g. they will offer the M1 and they'll go all the way to UPS 3 for anybody they employ. So details of the rates of pay you're currently on, including what you've been asked to do when undertaking your assignments. Details of the rates you'd received if you've been directly employed according to the school's pay policy. So again, this information, and that all the schools are under the same hirer, under the control of the same hirer. So again, this is just a bit of digging around in order for people like Colin, who's excellent in dealing with cases, to understand whether there's a legitimate case to take forwards. So enough of me. I think it is now time for Colin to take you through the process of making a claim. And Colin, if you're happy, I'll just click the buttons and everything. So you just talk in, we'll go from there.
Yes. Well, once again, hello, colleagues. Can I firstly say something about the agency worker regulations? Because most of the employment law in place, which currently affects you as a teacher, has been transcribed from European law. So what the process was that the European Union produced a piece of draft legislation, and then all member states had to transcribe it into their own national law, i.e. interpret the European Union law. Now, the British governments of whatever political colour were very good at taking the European law and giving a piece of legislation which, if you looked at it on the surface, appeared to confer rights to workers of whatever category, but when in practice they didn't confer full rights as indicated. I would say in the case of the agency worker regulations, that is not a case, an example of that type of case. It actually does what it says on the side of the bottle. It basically provides legitimate grounds for supply teachers to claim equal rights in terms of pay and other conditions. So I think there is fertile ground for the union to pursue this further in respect of testing it. And in terms of the law, I'm not aware of any test cases. There are cases which have gone to the employment tribunal and have been heard. But just for your own information, claims in an employment tribunal do not set a legal precedent. They're just there for information for further cases. It's only when they're tested at an employment appeal tribunal or a higher court that they then have the status of legal precedent. So we're in very early days at this stage. And of course, I'm very keen to test the law to push the boundaries out as far as possible to get a proper deal for our supply teachers. Now, the cardinal sin, if you press the buttons, Paul, the cardinal sin for any caseworker is to miss limitation, because all legal claims have limitations by which you should pursue them. And we are pursuing claims in Wales on the basis of the agency worker regulations and an unlawful deduction from your wages. And they have different limitations in respect of each. Well, they have the same limitation, but interpreted in a different way. So when we pursue it under the regs, it's 3 months less 1 day from the last day of assignment in the HIRA. For an unlawful deduction, that's slightly extended by the fact that the 3 months less 1 day applies, but it's 3 months less 1 day from the date you received the payment for that last day. And therefore, invariably, the claim under the unlawful deduction has a longer limitation period. But I don't think any caseworker should conscientiously go to the limitation to file a claim. If we have the information to lodge a claim, we should do so as soon as practicable. And another reason for this is that the coalition government, if you still remember that, introduced a process by which before you lodge a full employment tribunal claim, you need to go through a process called early conciliation. And that's quite a simple exercise to lodge. You don't need the detail at that stage, although it would be helpful to have the detail. And you lodge early conciliation. An ACAS conciliator contacts you, and then you put the the caseworker will put the basic outlines of the case there, and then they go away and seek to conciliate the claim. Now, in respect of the conciliation, I've never had a claim settled through conciliation. My own observations is that the ACAS conciliators don't fully understand the agency worker regulations. And if you've got an employer or a hirer trying to kick back in respect of the implications of the agency worker regulations, they're unlikely to engage. But it does have the effect of extending limitation by 1 month, 1 month after the end of the period of limitation, or if you lodge before limitation, 1 month from the date you've lodged, whichever is the latest. But as I said, I don't think a caseworker should conscientiously go to the limitation period in case they're caught out, and they should lodge as soon as practical, in my experience. Once we go through the conciliation process, your caseworker should have been fully conversant with the case. There's a process where we effectively triage potential claims, and they have to be approved by our legal department. And there'll be an assigned legal officer to support the caseworker in conducting the case. And then what's done is that the caseworker will lodge the claim in the tribunal on a form known as an ET1. And we in Wales are lodging against 3 respondents: the hirer, which is the school, and we lodge it against the governing body of the school. I appreciate that may not be the language which is news now in England, particularly amongst some of the academy chains. We lodge it against the agency, and we lodge it against the local authority. And once again, that's because we don't have academies in Wales. We lodge it against the local authority, who is still very much involved in education, in the running of schools. So I guess the equivalent in England would be that it would be lodged against the academy chain if it's different from the school itself. So we lodge all 3. The issue about lodging against the agency is that the agency is potentially on the hook, because if we win the case, the tribunal will decide where liability lies. And I'll go on more to that, to what's actually happening in Wales in terms of what agencies are doing to try and avoid liability in respect to that. So the tribunal will make the decision, then they say who is liable for the loss of pay in this occasion. Now, there is an issue in respect of limitation, which I've dealt with. In fact, it was the first agency worker case I came across, and I raised it with, this was a pupil referral unit, information about the correct rate of pay for the member I was representing. And when I was pushing on questions, quoting the agency worker regulations, lo and behold, they terminated her assignment. And you can understand why some members may be reluctant, in case that if they push this too hard, firstly ask for the information by all means, because I think you're required to do that. But you may wait until the end of the assignment before pursuing a claim. But do that as soon as practical. But there is a defence against the assignment being ended. And it's effectively Regulation 17 of the agency worker regulations, that they cannot subject you to a detriment, which obviously at the end of it, the end in the assignment is, for the act of asserting your rights under the agency worker regulations. Now, there is a process where effectively our claim will be filed, and the employer or the respondents, sorry, are required to make an initial response in writing. We find in Wales, the local authority and the hirer submit a joint response, and the agency submits their own response. The agency now is focused on trying to avoid, well, contesting the claim and trying to avoid liability in case the claim is successful. Now, Paul went through some of the arguments which are deployed, because what actually happens before you go to a hearing, you don't lodge a claim and the next week there's a hearing. There's a whole set of preliminary stages where the parties have preliminary hearings before the employment tribunal, where they effectively manage the case so that it's ready to be heard by a tribunal at a full hearing. And this is very useful, because what it does is that you can effectively glean from this the arguments which they're going to seek to deploy to resist the claim, plus the response which they initially respond on the form known as the ET3. And an effect is that they would say the standard response in responding to the claim is that if they employed this supplied teacher, they would have engaged them in Wales. We've got the benefit of M1 being removed, so the starting point is M2 for all teachers. They would have engaged them at M2. Now, we've got in Wales the benefit of comparative data. Paul has supplied me with some general data for average earnings for teachers. But of course, you can't translate those average earnings figures into what point on the scale that would be or equivalent to, because we can't take account of TLRs, ALN allowances and other allowances which may be payable to that person, which will obviously increase the average pay, but wouldn't be reflected in what point of the scale that equates to. But we've got data in Wales, which is produced by the Welsh Government as part of their submission to our own pay review body. And I can tell you, this is pre the abolition of main scale 1, that only 3.8% of teachers in Wales were on main scale 1. Just to give you an indication of M2, which is the new starting point, it was 3.9%. And for upper pay scale 3, 57.4%. Now that may reflect a number of factors. It may reflect that we've got an older teaching workforce in Wales, and therefore they've clocked up the experience and managed to pass through threshold. But it may reflect other factors, is that there's been the NASUWT has forced strict adherence to the school teachers' pay and conditions document, brackets Wales, close brackets. So we can actually then prove that the comparative data indicates that most people would be employed at a higher point. And the key question is, and this is a key question which is agreed between ourselves and the respondents in a case in the Vale of Glamorgan. It basically is derived from Regulation 5, and it just says, this is an agreed question, which is going to go before the tribunal. If the claimant had not been an agency worker, what basic working and employment conditions would the claimant have been entitled to had he, sorry, they just used male gender here, been recruited by the hirer? So effectively, there's an acceptance that the teacher would be on school teachers pay and conditions document, but would they necessarily, what point of the scale would they be on at that point? And of course, this is where their assertion is that they would employ them on M2 in the case in Wales, or M1 in England, is tested by the Bayes guidance. And I quote you from this because these are the agency worker regulations. They're generalized, so they're not applicable to teaching alone. They are not the teachers regulations, the supply teacher regulations. They are the agency worker regulations. So the Bayes guidance provides very useful indicator of how occupations with pay scales should be treated in interpreting Regulation 5 of the agency worker regulations. And it's on page 27 of the Bayes guidance where it says, where a hire has pay scales or pay structures. And it talks about compliance with Regulation 5. And it says here, yes, if the hirer, and it talks about whether putting them on the bottom of the scale is compatible with Regulation 5. It says, yes, if the hirer would have started the worker at the bottom of the pay scale if recruiting him or her directly. But if the worker's experience would mean starting further up the pay scale if recruited directly, then this is the entitlement. That's the actual quote from the Bayes guidance. And of course, the position of, yes, it's school teachers pay and condition documents Wales. The issue is at what point is supported by the adverts which they advertise for roles in the school. So some members have collected adverts for positions, which maybe is one of the the sources we've neglected to put in the checklist pool. So traditionally, so in Wales, what people do is advertise on the basis of M2 to UPS 3. And of course, what that means is that there's a considered decision taken by the school in this case, where to place this person on the pay scale. And of course, what informs that considered decision? And we would say that the principle of pay portability does apply. And in Wales, I'm sorry, I sometimes don't keep up with all the developments in the English pay system, but at the time that England was removing pay portability from the current school teachers pay and condition document, pay portability has been reintroduced or introduced as mandatory. So it does apply. And what the agencies then try to do to say is that pay portability doesn't apply to supply teachers. Well, that's incorrect, because that's an incorrect interpretation of the test deriving from Regulation 5. Because it says, if you employed this person directly. If you employed this person directly, they would not be a supply teacher. So the issue of applicability of pay portability, where it does apply, is not an issue, and it's a false argument, which I've detailed to the agencies on many occasions at these preliminary stages of the process. So pay portability, right, is a non-issue, and I'm absolutely confident that should we go to a hearing on these we would defeat that argument. Now, the issue is then it's the same role, and Paul given quite a detailed thing. I absolutely agree, subject or key stage or so forth. But what they're trying to do in Wales is they're trying to say they're doing it task orientated as well. That there's certain duties which you don't carry out as a supply teacher. But the basic argument applies to defeating that argument as well, that the person was engaged as a teacher. And how you deploy those people is up to you, provided it's within what they were employed to do in the first place. So the question is, it's your responsibility to deploy these people. And besides, your position on the pay scale is not determined by the tasks you undertake. It's natural progression from M2 to M6, although Paul will probably tell me that's changed in England as well. And then there's the threshold test at M6 to go into UPS 1. And then it's natural progression on a 2-year cycle up to UPS 3. So it's not determined that. And there is an interesting thing which is coming out in terms of liability as we begin to test their arguments, that quite clearly the agencies are beginning to see that there is liabilities. Now just think of the business model which they're based on, right? Hopefully there's no one from the agencies here who happens to be a member, but it's a totally parasitical and exploitative model. And we need to end it, right? And this was gloriously revealed in that Vale of Glamorgan case, where when we were agreeing the basic questions to put before the tribunal, it said the claimant asserts that he was paid a daily rate of 141.71, which equates to M2 on the main pay scale. The first and fourth respondent, that's the school and the local authority, assert that they paid the second respondent a daily rate of 195.57 plus VAT. And the second respondent, which is the agency, asserts the claimant was paid at M2 rate on the main pay scale. And there you've got, gloriously, the charge-in rate from the agency. It's money for old rope. Effectively, the claimant here, or our member, gets £141 per day, and the agency gets over 50 quid per day. Nice work if you can get it for the agency. And it's no surprise that the agencies are promoting themselves by taking out boxes at the Liberty Stadium in Cardiff, where no doubt they wine and dine head teachers, in the hope that they can drum up more business to employ supply teachers through these at this exploitative way. So the agencies are there to protect their business model, and at the moment the schools and the local authority have not caught up, because the defence of the agencies is primarily to avoid liability, and that's regulation 14. So when the tribunal makes a determination, let's hope it's a positive determination in support of our case, what actually happens then is that the tribunal determines liability, and it could be one of the 3 respondents or shared amongst the 3 respondents. What the agency does is effectively sends the school in Wales, and it's the premier agency in Wales, I won't name names, they send a pro forma to the school and say, what rate should we pay this at? Person at. And the school then says M2, right? It's invariably M2, right? Back it goes, and the agency pays that. I don't think that's sufficient to protect themselves from being liable, because they have to take reasonable steps to establish the correct rate of pay. And merely getting the school to complete the pro forma is not sufficient, because this agency was the preferred supplier of supply teachers. Too many supplies there, but it was the preferred provider of supply teachers to Wales schools until recently. To do that, they must have knowledge of the school teachers' pay and conditions document. And I suckered them in the first case I did, because I actually made that in a response to what's known as full and better particulars, where I said they have full knowledge of the school teachers' pay, and they actually agreed. So on what basis, if they've got a teacher on their books who said that when I was last directly employed, I was last directly employed at UPS 3, and the school fill in the pro forma and say M2, they know full well that that's not the appropriate pay point, and it's a point I'm going to make. But the problem is that the schools and local authorities are too stupid to realise the agency are basically trying to drop them in it. And my job is to play them off against each other, right? So that they pass the buck in terms of liability. I want to win the case. Who pays up in the end, I don't really care. But I'm not going to let the agencies get away with it. And at the heart of this, sorry, I'm now going on my soapbox, Paul, if you don't mind, right? At the heart of this is this rotten business model they've got here. Because if you think at the heart of this is that effectively schools can pay the M2 rate and the agency fee, the charge-in rate, and still get a teacher cheaper than what they would be had they been directly employed. And of course, the reverse of that is that if we successfully enforce our interpretation of Reg 5, the agency worker regulations, so in this case, the teacher would be paid at UPS 3, but also add on top of that the charging rate, it becomes more expensive to the school. So surely then schools will start saying, well, why don't we directly employ this person? And of course, what we want to do as a strategic thing, because, I don't know how many caseworkers the NASUWT employ, but there's potentially hundreds, if not thousands, of claims out there. And it's dysfunctional to pursue claims on behalf of everyone. What we want to do is establish the position where academy chains, agencies and schools realise it may be in their best interest to employ people directly where it's a medium to long-term fixed term cover. And we want to drive the agencies back to a position which they formerly had, where someone will ring up and say, the geography teacher's rung in sick. Have you got a geography teacher who you can supply to this school today? Day-to-day supply cover. That's what we want to drive them back to. But at the moment, too many schools are using, too many schools are using the supply agencies to get cheaper members of staff, and the agencies are complying with that because they get the fee. Now, in terms of the tribunal stage, right, the documentation, they require a statement, a witness statement, and any evidential documents. The evidential documents are the ones Paul's asked you to bring to the party in pursuing a claim. And no doubt more of it will come out once we start making questions. We can ask for disclosure. So one of the things we could do, right, is in academy chains where perhaps we don't have the same amount of detailed information in terms of the spread of teachers in that particular academy chain or school, spread across the pay grades, we could actually ask for disclosure of that information. How much do you pay these people? And we can then raise the case and get the employment judge to order disclosure of that information through the tribunal process. So at the hearing itself, you will be asked to prepare a statement. Now, I wouldn't have any qualms about that. And this is not like an employment tribunal for unfair dismissal, where it relates to the conduct, and it's basically the claimant or our member is given their side of the facts here. Effectively, you know, all your statement will say is that I was employed through this agency, worked at this hirer between these dates on this number of days. It can't hardly say any more. I was engaged in these tasks, and the issue will be mainly for your caseworker to make submissions based on the interpretation of the agency worker regulations to win the day. Now, you may get questions about the tasks which or your responsibilities while you're working there, but your caseworker should be able to dismiss those. So I would say that in terms of the process itself, it shouldn't be very stressful at all. I know some people have reservations, understandably, about appearing before a tribunal. I'm perverse. I quite enjoy them actually, but you can actually see how these processes work, and once you get in there, there is nothing to be stressed about. All I can say is that at the moment, we've got to build up a critical mass of cases. Supply teachers have told us at the consultation forums how they're being exploited. The point for the union is to change that, position and improve the lot for our supply teacher members. We need to build up a critical mass of claims. Provided we win some of these claims, we then need to go back to the agencies and the employers, either the local authority or the academy chains, and reach collective agreements about how supply teachers should be paid when they're engaged in those schools. And through taking a collective approach like that, we can best serve the interests of other supply teachers, so that supply teachers would not have to undergo this process of having to submit employment tribunal claims. So I would leave it there, Paul, at that stage, and we can then hopefully take questions about going forward. I encourage you all, if you think you've got a case, to take it forward through your regional centre.
Thank you, Colin. I think that was a really excellent outline of the process, particularly the specifics of taking somebody through a tribunal. I hope this has been useful for colleagues this evening. We've got a number of questions, Colin, so I think some of them have been answered, but I'll just put them out there. One from Laura O'Farrell. I've been told as I'm not planning, I'm not entitled to AWR. I think you answered that question earlier on, Colin, because you said, well, you're employed as a teacher. It's up to the school how they deploy you, and clearly they could ask you to do planning, or they could not. But I don't necessarily think it's a reason to deny you equal pay under the AWR. So I don't know what your opinion is, Colin.
Yeah, it's precisely that. In effect, you deliver the lessons. To what extent, I know planning's important, but to what extent do you deliver a lesson solely from a plan? It's just it's a guide and relies on a lot of your responsibility to actually deliver the lesson as well. So you're engaged as a teacher, in my view.
I mean, I think the other point to throw out there, which is often can be seen as contentious, is quite a number of multi-academy trusts I deal with now. They pay people to plan lessons for curriculums. So the teachers themselves who are delivering the content haven't necessarily been involved in the planning. Now, for you, Laura, that doesn't mean that those teachers are all being paid at a lower level, because those teachers will still have progressed, as Colin said, through natural progression. And we all know, because certainly when I was a teacher, in some departments, if you are a new teacher, you may not do the planning because other people are doing that planning for you as you gain your experience and expertise. Now, that doesn't mean you are paid on a lower level, because you still can get natural progression, but other people are doing a lot of the planning and you're still delivering the content. So I think it's a bit of an interesting argument. I don't agree with that argument, because you're not doing planning, you're not entitled to AWR. And I think, that needs to be challenged. And it'd be interesting to see whether that's come from the agency and the school, or both. I think somebody had the hand up just now. Laura, you said thank you. We've asked your questions. So Deborah says, have you represented members on day-to-day supply where they're not paid the correct rate? Agencies, including our partner, the TSR, would not pay to scale, but despite advertising otherwise. Well, from my point of view, if you've got evidence that you've acquired the relevant eligibility under the agency workers regulations, we'll pursue a case whether it's TSR or not. I don't really care who it is. If there's a legitimate case to be pursued, then, but we'll pursue it.
But Paul, what I would say in respect to this is we're at early days, right? Schools or the agencies can make their case. My job is to make our case, right? And at some stage, there'll be a determination whose case is right, all right? But don't let them prevent you making your case by saying you haven't got a claim, all right? It's for the union to pursue the claim to establish whether you've got a claim or not.
Yeah, and if you think about what we said tonight, Deborah, it clearly goes back to this evidence gathering. If the evidence is there and we can make an assessment of your claim, then obviously we are entitled to pursue your claim on your behalf. Now, some claims may be pursued, some claims may not, but it's always based on a test, isn't it? And the test that sort of Colin's alluded to tonight, and the test that Colin does in terms of the merits of the case. So if you think there's a merit to your case, you've gone back and you've done the homework over the information I said would be crucial to gather, and an assessment can be made, and I know you're in the East Midlands, by the East Midlands Regional Centre as to whether there is a case to pursue. And as I said, it doesn't matter who it is, we will pursue that on your behalf if we think the merits of the case warrant it. I know, Deborah, you've got another question there, but it's about SSP, which is not something we're necessarily talking about tonight. I don't know, Colin, if you want to answer it anyway, but it just says, Deborah said, regarding SSP, please say whether this is the case. Agency workers are only entitled to SSP when they're on an assignment, and any entitlement to SSP ends when the assignment ends. There is no entitlement to SSP during periods when the agency worker was not due to be on an assignment.
I'll let you answer that one, Paul.
I think there's an argument. It depends on the contract you're on. Contract of services or contract for services. I think it gets quite complicated. And in some instances, yes, you're not entitled to SSP if you're not on an assignment. If you're due to be on assignment, then you can claim SSP. But again, it would all be based on the contract that you've got in terms of that employer.
Shall I take Laura's question next?
Yeah.
So
I answered that one, I think, Colin, about the daily rate.
Okay, that's probably when I was dealing with my ex-wife. Sorry about that. But
No, I answered it because I said it's divided by 195.
Yeah.
Or in Wales as it is 193 this year, because sensibly Wales have changed the teachers' pay and conditions document, whereas in England it's still 194. We've yet to have the official confirmation it'll be 193. But yeah, it's based on the days that you can be expected to work, and teachers only work 195 days of the year. but for this year only because of the coronation of King Charles III, which happens next year, and also the death of Queen Elizabeth II. That means 2 bank holidays for those mean you can only work 193 days. So that does actually mean your daily rate will be upped if you work on that principle. Right, Maureen, do you see that question, Colin? Maureen's got a question. Can you claim AWR for working continuously for an agency at different schools, 3 schools over spring, summer term? My initial gut reaction would be, Maureen, it depends on if they're all the same hirer. So if it's 3 schools and local authority employees, there are 3 schools at local authority schools, there's an argument, yes, you could have got to the 12 weeks. Or if it's the same schools in a multi-academy trust.
Yeah, that's the connected hirer
issue
which Paul addressed earlier on.
Right. And Rosemary says, I've been to complete a one-to-one role at private house as alternative provision. I've refused, but would like to discuss this another time, Paul, as I think it's not part of the discussion. Rosemary, I'm happy to type in your answer, my email, come back to me and we can have a chat about that, because I would be concerned about that. Private house, health and safety throws up lots of health and safety issues. I know certainly working in my old local authority, not teachers obviously, but people who did social care, lone worker policies, are you working at night, stuff like this. So I think it raises some issues. So I've put my email address in and come back to me and we can check this out. I'm not putting it in properly, so I'm just making sure I have put it in properly. So hopefully you will have that. Come back to me and we can deal with that. I'm just looking. I don't know if we've answered. We've got 6 questions. I think we've answered all the questions that I can see. There's some stuff in the chat. Right. So Sarah, we did say put the questions in the Q&A box because it's a lot easier to filter and look at them. But you've asked, what if you worked 1 day a week but was not required to attend staff meetings nor planning? How could you argue you deserve the same pay even though you'd be working less additional hours than the other staff? Well, there are situations where teachers in the school who are on the upper pay range who don't attend staff meetings because the staff meeting is not relevant for them. And I can say that with the experience because I was head department myself. And when I was a teacher, if the meeting or parents' evening was not relevant to me, I wouldn't attend it. And that was perfectly reasonable within the school I worked in. So if you're not teaching year 7, why would you attend year 7 parents' evening? That doesn't mean suddenly somebody says to you, well, we're going to deduct some money from you. So again, I think I can see what the logic of the argument is, but I don't think the argument stacks up because there are lots of situations where people wouldn't be expected to attend certain events and nobody deducts some salary for not doing it.
But it doesn't meet that substantially different test in the BIES guidance as well. Essentially, it's the role of a teacher. Yeah.
So the role of a teacher, so the role of a year 7 teacher might be to attend parents' evening, the role of year 9, but it's still the role of a teacher. So I'm not convinced by that argument, Sarah. I can see what you're saying, but I'm not convinced. I'm just checking the chat before we go. Right, I think we've addressed all the chat, Colin. Oh, there are a couple more questions popping up. I think, Rosemary, I should have put it in my answer to you, but I will put it in the chat, Rosemary, as you didn't get it. And then an anonymous attendee has said, Colin, as a one-to-one tutor working through an agency, how can I establish a fair hourly pay rate? I've been through threshold and PSIs and was an assistant head teacher in the past. I'm trying to think if the regulations would apply in that situation.
I don't think so on the surface.
No. Who's the hirer? That would be the key thing for me. And then obviously you've got an issue if the hirer, if you're tutoring, then who is the hirer and what are their policies and practices and procedures? So we're probably mainly dealing with, unfortunately, anonymous attendee, dealing mainly with people who are working in a school setting or school-based setting, not one-to-one tutoring. Rosemary, I'm just going to pop my email into the chat for you. I think, Colin, we can bid farewell, because I think most people, we've answered all their queries. Oh, we've got another question. It's almost like every time we try to say we've answered them all, somebody throws another question in. Right, okay. I can't see the next question. Maybe there isn't a question.
Yeah, the numbers seems to be going up. Do they start?
Numbers are going out. I can't see any more questions. Oh, right. It's Raquel Hamilton Vicar. How is it going with the union pursuing the possibility of teachers ringing the school directly or to be employed as the visiting supply teacher? Well, obviously, Raquel, we did some training on this at the most recent supply event. I've done certainly training on this in terms of, if you're new to supply teaching, what you can look at. There is absolutely nothing that prevents any of our supply teacher members from pursuing the possibility of teachers working directly for a school. We are engaging with employers where we can to try and get them to see good sense and work, as Colin said, on a model that directly employs you. And we have had some success. For example, the academy chain Reach South in the southwest of England have told us that they are looking to build up a bank of supply teachers they directly employ. Now, obviously, that doesn't guarantee you work, but what it does is it says when you are working through them, you'll be employed directly. So we will continue to campaign for that as an alternative to the current situation. But obviously, in terms of ringing schools, that sits with the individual supply teacher to see if they can get engagement and work directly by them working through their own means to secure that. Right, and then Emily has got a question, Colin. Is it all still the same role that I was also listed as a satellite school one-to-one teacher as well as supply teaching at the rest of the same school? I think I'd need to look at what more specifics, Emily, about what you say you're doing. But in essence, the argument Colin and I have articulated this evening is, when are you not teaching? When are you not a teacher? If it's one-to-one teaching, what's the difference between that and supply teaching? What's the difference between that and teaching? In schools, it's quite common for some teachers, to have groups they take out and do one-to-one teaching with. Particularly, I can think of some SEND situations where that happens. So I don't know, Colin, if you've got a different take on that, but I think teaching is teaching. And so I don't see that being substantially different, which is the criteria. Are you still expect to do the same thing, Emily, as you're doing in your supply teaching with the rest of the school? I would suggest, yes, you are. You're supposed to teach that child on a one-to-one situation, and you're still teaching in group settings, but it's still teaching. The essence of the job hasn't changed substantively in my mind. Right, keeps going up, Colin. We've got 15 questions now.
Okay.
Right. I think somebody's put a thank you in the so that's okay, Raquel. You're not a problem at all. Supply teachers in a vulnerable position whereby agencies may not offer work if they pursue a claim. I do appreciate that, Shirley, and I do think that's a real live issue. But obviously, we have to do the best by you as an individual as best we can, and that does involve, if we think you're entitled to this, to making a claim. What we shouldn't do is be silent on this, and we should look to pursue claims where we can. And as Colin articulated earlier on, you can, if you suffer a detriment, e.g. they don't offer you work, then we can tack that onto the claim. Right. I think, Colin, we've answered all the questions. And at
one more from Galaxy Tab A, Tara.
Oh, where's that come in?
It just come in at the bottom.
I can't see that one.
Well, it popped up, but I maybe that's a chat.
Oh, it's in the chat.
Okay.
I'm not sure if it's a question or comment anyway. Right, well, can I just take time to thank Colin for giving up his evening. I think it's excellent to get the perspective from a caseworker, and hopefully you found this session informative, and we've given you some advice and guidance and some things to go away and think about. But as Colin said, if you think you've got a claim, you've got the evidence, then obviously do contact your regional centre and see about next steps, and they should assess the case and the merits of the case. And we'd like to think that, if there's a case to answer, we will pursue that for you on behalf of you as a member of the union. So thank you for your time. Wish you all the very best. If we do not see each other before Christmas, which is quite likely, then have a good Christmas and a very safe, peaceful, prosperous new year. Take care, colleagues. Bye.
Bye-bye.